Hello, this is your attorney, Jiwon Lee. Beginning from now, I would like to provide very useful tips when you face any criminal charge. I'd like to call it the ultimate guide to criminal law in Korea. Well, it might sound very boring and difficult, but since we're not in law school, I'll brief the basic features of the crime and introduce major issues regarding the crime in real-life situation, including tips. For our first topic, let's look into the crime of violence, as known as assault. Korean Criminal Act Article 260, Crime of Violence. A person who uses violence against another shall be punished by imprisonment for not more than 2 years, a fine not exceeding 5 million won, detention, or a minor fine. The crime of violence, or also known as the crime of assault, is a commonly committed crime in our daily lives. One of the most often asked questions is whether a crime of violence occurs even if there hasn't been any direct physical contact. The answer is yes. The judicial precedent states that any action that could possibly harm the victim can be interpreted as violence, whether it's direct or indirect. Under such precedent, even the indirect interaction which does not involve a physical contact, such as pouring coffee at someone or a direct blow to someone's ear, for example, can be punished as a crime of violence. Suppose there was a fight between individuals and you are in trouble for a police investigation. There are 3 things that you should always remember when you're involved in an assault case, whether you're an assailant or a victim. First, if there was any physical contact with the other party, always leave a medical record after the contact because it will be the key evidence to prove that you have been attacked. Just so you know, in Korean hospitals, in case of a slight wound, typically most of the doctors will diagnose it as an injury which will take 2 weeks to heal completely. Well, that typical 2 weeks is enough to make a crime of violence case. Second, most of the assault cases happen in a 2-way process, so when there's a police investigation, always make sure to make a statement that the fight was not one-sided. This is because one of the common defense strategies in assault cases is that the action was taken as an act of self-defense, and therefore you have to make a clear statement that you were also suffered by the assault. Third, remember that the crime of violence is the crime not prosecuted against objection. Criminal Act Article 260, Section 3. The crime of violence shall not be prosecuted over the express objection of the victim. Therefore, if the victim does not wish to continue the complaint against the other and drops a charge, then the assault case is immediately dismissed. This is the reason why I mentioned that always make sure to make a statement that there was a fight between the two and both suffered with the fight. Due to the existence of the no prosecution against objection clause, there is always a possibility of closing the assault case by the consent of both parties to drop the charge. Well, no one wants to be a criminal. So always remember the 3 things I told you today. And if you have any further questions or if you are already struggling with any legal issues related to today's topic, please feel free to contact down below and I'll be on your side. Again, this is your attorney, Jiwon Lee. Thanks for watching.